Hello students, welcome back to this channel. Today we will be starting with essentials of contract. In the last class, we have studied uh, the basic concepts of few topics regarding the Contract Act, what is contract, and to understand the contract, we have understood the various concepts like the what is agreement and what is promise and what is consideration, set of promise, all these things. If you haven't checked it out yet, just go with that video first and then come to this video. Okay, why we are referring this term valid contract? If it is not valid, then there is no questions of the essentials. We are concerning that what is the contract, means for the valid contract, which essentials or the which elements are needed. So what is the valid contract, what is not valid contract, we will discuss on the later class. But today we are just discussing the essentials or the elements of to be elements of the contract, means elements of making a valid contract. So the first one is there should be two parties, no doubt about it. Minimum two parties. Okay, minimum two parties. So because it is the promisor, means who is making the promise, promisor, and this promise is going to this B, means here this is the promise and B is accepting the promise. So the acceptance, and here the B is the promisee, because B is the responding towards the promise. So who is making the promise? That is the promiser, and who is accepting the promise? We are accepting the proposal. That is, it is proposal. So this, out of this transaction, it is promise. We have read it already in our last class. So promise, who is making this promise? This is A. A is starting to make this promise. This is the promiser, and here it is the promisee, because the promise, A is forming the promise because he is proposing something and B is accepting something. So here it is the promiser and promising. So it is the first element, that is there should be minimum two parties. Now question is, why I am referring this term minimum? Can it be more than two parties? Definitely, but minimum two parties. In other side, it can be like this, means A is offering or is proposing something towards this two person. Can it be happen for the partnership and all. Now move on to the next element, that is competent to contract. Competent to contract. Who are the competent parties? Who are the competent parties? Means here the competency to make a contract will be checked. Like the person should be 18 years old. Means we cannot make a contract with a minor person, means who are under 18 years old, who is not major. Here it is major. Next, should be sound mind. Sound mind. Okay, means who is not insane or the unsound mind. Okay, means who is the state of mind. Now, third is lawful consideration. Lawful consideration and lawful object. We know that in a contract, an agreement which is enforceable by law is contract. Now, agreement, the promise or set of promises which are forming the consideration, means to be a contract, there should be a consideration. The consideration should be the lawful, not the unlawful. What is unlawful? Which is forbidden by law. And for what? For the lawful object. I am giving an example. Suppose Mr. A and Mr. B is making a contract that if he will purchase his house in a very high price, then this person, Mr. A, will give some drugs to that person B in excess. This is the consideration. So is it lawful drugs, exchanging of drugs? It is not. So it is unlawful consideration. So this contract will not be valid. So in a contract, the consideration should be lawful and for the lawful object. Means I am giving you a rent of my house and it is for unlawful weapons. You are using for unlawful weapons. I didn't aware of it. I have just give you the rent just for your residential purpose or can be it commercial purpose. But I didn't aware of it that you are using my house as some unlawful weapons or you are you are connected with something with this unlawful purposes. So it is not the lawful object. And if I was aware of it and still I am giving it you the permission and you are paying a high amount of rent, then it is also it's an invalid contract because it is for unlawful object. So lawful consideration and lawful object should be there to form a valid contract. Okay. So now fourth one is free consent. It is very important and it is a depth concept. We will discuss this concept separately in the later class. So free consent means I am not forcing you to accept my proposal or to making the proposal. I am threatening Mr. B to accept my proposal. It is not the free consent. Consent means your willingness, your willpower. You are willing to purchase this car. It is a free consent. But I am threatening you or someone is threatening me to make the proposal. It is also not free consent. I am not free to create my proposal or to create my mindset. It is under the threatening or it is under the fraudulent or misrepresentation or the force, coercion. These terms will be discussed later on. Don't worry. But still understand the free consent means it is the external force which are forcing me to make this proposal or this acceptance. So it should not be there for a valid contract. Valid contract should be spontaneous, like free consent from both parties. Okay. So the fourth essential is free consent, and the fifth one that any contract which is not declared as void, means which contract from the first time it is declared as void, it can't be a valid contract under any circumstances. Because if I am making a contract with a insane person or unsound minded person, means who are not in his state of mind that to make the decision that what is wrong and what is not, I am making a contract with that person and I am claiming that that contract is valid. No, this contract is not valid. We have read in the first condition, sorry, second condition, that the party should be the competent. The party always the competent party. Okay, so here the 1 is there, 2, and this is the 3, this is the 4, and this is the 5. These two are the part of this. Okay, these two are this part of this. I have missed the sequence, so don't get worried about it. This is the 3 and 4, 5, and these two are the sequence of this point number 2. Okay, so in a brief, the essentials of contract are: first is minimum 2 parties in a contract should be there, and the competency of the parties, there should be the 18 years old, sound mind, etc. And third one is the contract should be for lawful objects and the lawful consideration. Fourth one is free from all external forces. And fifth one is the contract or the agreement initially from the starting, it's not declared by the law as void. If the contract from the starting, if the agreement from the starting is valid, we will move forward to check the other essentials, whether it is valid contract or not. But it is from the starting, the contract itself void, then there is no question to move forward with the other essentials. When the agreement is void from initial stage, then it is void contract. Means it is the contract, it is not the contract, because it is not enforceable by law and because it is void declared by law. I am ending up the class here. If you like this video, please do like, share and comment down below, and please do subscribe our channel. Your little effort will motivate us to make more contents like this. Thanks and keep watching. Thank you.